can get started, Eric.
Eric, can you hear me?
Yeah.
Okay, let me know if I'm probably going to read most of my remarks so as to be efficient about handling the information and allow people to get in. I wouldn't want to filibuster for the whole hour in the court. So human rights law and international humanitarian law are two related domains of international law, with roots traceable in the early origins of civilization, but with significant modern codification during the post-World War II era. Today, I'm going to discuss different sources of law for international humanitarian law and human rights law, with comparable degrees of acceptance amongst nations, and with distinct procedures of implementation. Before I begin, I want to thank Courtney Baker, Carrie Ann Jones, Laura Matson, and Ethan Scrivener for their help in preparing this presentation. So, turning now to sources of law. The principal sources of international human rights law include the UN Charter, the International Bill of Human Rights, including the Universal Declaration of Human Rights and the two covenants on human rights, more than 150 other human rights treaties developed by the United Nations, including treaties on genocide, slavery, racial discrimination, discrimination against women, torture, rights of the child, migrants, the disappeared, and the disabled, and many more. There are also human rights treaties and other instruments developed by regional institutions, such as the Council of Europe, the Organization of American States, and the African Union, as well as the International Labor Organization and other specialized agencies. International humanitarian law is principally based, as we know from our presentations yesterday, on the four Geneva Conventions of 1949 related to the wounded, sick, shipwrecked, prisoners of war, and civilians in international armed conflict. The first additional protocol of 1977 expands protections for victims of international armed conflicts, and the second additional protocol of 1977 modifies the protection of victims of non-international armed conflicts, which is also addressed by Common Article 3 of the former Fourth Geneva Convention of 1949. Many provisions of the four Geneva Conventions, the two protocols, and the Hague Convention of 1899 and 1907 are broadly accepted as customary international humanitarian law, which is applicable to all countries. Further, human rights law includes treaties limiting the use of biological, chemical, and nuclear weapons, anti-personnel mines, and cluster munitions, as well as the trade in small arms. In general, humanitarian law treaties deal with international and non-international armed conflict. Human rights treaties protect individuals from violations during times of peace or armed conflict. There are some overlaps between human rights and humanitarian law instruments, such as the Genocide Convention and the first optional protocol on child soldiers to the Convention on the Rights of the Child. Article 4 of the Covenant on Civil and Political Rights provides that certain rights are non-derogable, that is, are not subject to exception, even during periods of public emergency which threaten the life of the nation, such as armed conflict. Those non-derogable rights include the right to life, freedom from slavery, freedom from torture, freedom of thought, conscience, and religion, prohibition of imprisonment for debt, prohibition for ex post facto laws, and the recognition of all persons before the law. The African Charter on Human and People's Rights, the American Convention on Human Rights, the European Convention on Human Rights also recognize certain rights as non-derogable. Now, turning to the ratification of human rights and humanitarian law treaties. The most broadly accepted humanitarian law treaties are the four Geneva Conventions of 1949, as Eric mentioned yesterday, which have been ratified by 195 nations, while there are 173 states parties to the first additional protocol of 1977 and 167 states parties to the second additional protocol. There are 100 parties to the Convention on Chemical Weapons, 190 parties to the Treaty on Non-Proliferation of Nuclear Weapons, 169 states parties to the Convention on Biological Weapons, 161 to the Convention on Anti-Personnel Mines, and 84 to the Convention on Cluster Munitions. By comparison, the most widely accepted human rights treaties include the UN Charter with 193 member states and the Convention on the Rights of the Child, which has similarly 193 states parties, but not Somalia or the United States. There are 187 governments that have accepted the Convention on the Elimination of Discrimination against Women. The Economic Covenant has been ratified by 160 nations, the Civil and Political Covenant by 167. Other treaties that have been ratified by varying numbers of governments include racial discrimination, 176, child prostitution and pornography, 165, child soldiers, 152, torture, 153, genocide, 143, smuggling of migrants, 148, and the disabled, 134, etc. The most effective mechanism of enforcing international law is for each ratifying government to incorporate its treaties and customary obligations into the national laws and practices of that nation. For example, the Constitution of the Netherlands states that any ratified treaty is part of the national law and even prevails over the Constitution. Other nations consider treaties to have the same status as statutes, such that they may be asserted in any court and must be followed by the government administration unless there is a more recent statute or treaty. Countries that automatically make international law a part of their national laws have been characterized as monarchs and often reflect civil law systems. Many other nations, particularly those countries that follow the traditions of the common law begun with the United Kingdom, generally follow a dualist approach to international law. In addition, there are some countries, such as Japan and the United States, that take a compromise position in which they pursue some aspects of each approach. The principal responsibility for implementing humanitarian or human rights law falls on the ratifying government to fulfill its legal obligations. Accordingly, for example, each nation is expected to comply with the 4 Geneva Conventions and 2 additional protocols. Under Common Article 3 to the Geneva Conventions, both states and armed non-state actors are responsible for fulfilling their responsibilities in non-international armed conflict. The International Committee of the Red Cross monitors compliance with the Geneva Conventions and protocols by visiting places of detention, making approaches to authorities, using its right of humanitarian initiative, and receiving complaints. There are many different ways by which human rights standards are implemented at the international, regional, and national levels. For example, by ratifying the 9 major human rights treaties, that is, multilateral treaties relating to economic, social, and cultural rights, civil and political rights, race, women, torture, children, migrants, the disabled, and disappearance. Governments agree to report periodically on their performance, to appear before a committee of experts and answer questions, to have their performance evaluated, including remarks by the relevant committee, and then to produce further reports responding to the concerns of the 9 treaty bodies. 6 of the 9 major human rights treaties can also receive and adjudicate complaints by individuals against governments in regard to governments which have accepted those procedures. Unlike the International Committee of the Red Cross that can receive information but doesn't adjudicate in regard to those complaints. The decisions on and views of treaty bodies in regard to human rights individual complaints are issued by the relevant treaty bodies. They also issue general comments that help build a substantial interpretive jurisprudence of human rights. In addition to the procedures authorized by the 9 main human rights treaties and their respective treaty bodies. The UN has established, under the authority of the UN Charter and the General Assembly, as well as under the Commission on Human Rights, which has recently been replaced by the Human Rights Council, a number of charter-based procedures. For 1, reporting on 36 human rights themes; 2, reporting and expressing concerns about a dozen or more specific countries where there are serious human rights violations; elaborating further on human rights norms; and a few of the thematic and country rapporteurs focus on both human rights and humanitarian law, such as the UN Special Rapporteurs on arbitrary killings, mercenaries, terrorism, and torture. The UN Security Council has on several occasions identified human rights crises which threaten the peace and which require an on-site presence of UN peacekeepers and human rights monitors. 36 other nations have accepted the presence of UN human rights monitors or at least assistance officers. The Security Council has further established 2 ad hoc criminal tribunals for genocide, crimes against humanity, and other grave violations of humanitarian law in Rwanda and the former Yugoslavia. A more broadly applicable international criminal court, as we all know, has been established to investigate and punish war crimes which are largely defined by humanitarian law, as well as the crime of genocide and crimes against humanity, which include the most serious violations of human rights and humanitarian law. The statute of the International Criminal Court came into force in July 2002, and 122 nations have accepted its jurisdiction, but not the United States. Most advocates and scholars would also consider within the domain of human rights law and humanitarian law a few of the relevant decisions of the International Court of Justice. The Court first referenced human rights law in an advisory opinion, stating that reservations to the Convention on Genocide must be consistent with the purposes of the treaty in order to be upheld. The Court also used human rights law in its advisory opinion relating to the detention of U.S. diplomatic hostages in Iran, saying that depriving individuals of their liberty and otherwise constraining human rights is manifestly incompatible with the principles of the Charter of the United Nations and the Universal Declaration of Human Rights. Furthermore, the International Court of Justice referred to humanitarian law when it found that the U.S. had violated Common Article 3 to the Geneva Conventions by encouraging the Contras in Nicaragua to execute government officials without judicial guarantees. The interplay between human rights law and humanitarian law was again considered by the Court in dealing with the building of a wall between Israel and the Palestinian territories. The Court also mentioned the human rights and humanitarian law implications of the use of nuclear weapons in its advisory opinion. In addition to the intergovernmental efforts and international legal provisions, there is a large and growing non-governmental human rights community which uses international law and advocates or lobbies for human rights at a local, national, regional, and international level. For example, 2 prominent non-governmental organizations, Amnesty International and Human Rights Watch, have used both international human rights law and humanitarian law in advocating for the protection of the rights of individuals in various countries. Human Rights Watch was founded as Helsinki Watch in 1978 and promptly started the application of the final act of the Conference on Security and Cooperation in Europe, known as the Helsinki Accords in 1975. By 1981, Human Rights Watch had expanded to the Americas and other parts of the world, focusing on humanitarian law with less attention to human rights. Now, Human Rights Watch is pragmatic in citing whichever legal norms appear applicable. Amnesty International, on the other hand, was founded in 1961 and focused principally on the Universal Declaration of Human Rights and other human rights instruments. By 1981, Amnesty began to recognize the usefulness of citing both human rights and humanitarian law as relevant to particular situations. There are also regional human rights structures in Africa, Europe, and the Western Hemisphere. These regional organizations adjudicate complaints, engage in fact-finding inquiries, and promote human rights. The Organization for Security and Cooperation in Europe promotes and monitors human rights in the region. The Helsinki Accords authorized the OSCE and have had a significant impact on the prevention of ethnic conflict and the deterrence of discrimination. The European Court of Human Rights has relied on humanitarian law principles to resolve issues that have come before it. For example, the Court used language of the Fourth Geneva Convention of 1949 in its determination whether death caused during state security operations constituted an arbitrary deprivation of life under the European Human Rights Convention. In its Las Palmeras decision of 2001, the Inter-American Court resolved that it did not have competence to determine whether a given act was in violation of the 1949 conventions or other treaties other than the Inter-American Convention. Humanitarian law generally lacks an individual complaint procedure or fact-finding mechanism comparable to human rights implementation procedures. Article 90 of the first additional protocol to the Fourth Geneva Convention, to the Geneva Conventions, authorizes the establishment of a fact-finding commission to investigate complaints regarding violations of human rights and humanitarian law. As I think Dick mentioned, the parties to the complaint are allowed to submit evidence, and members of the fact-finding commission are also able to investigate the grievance. After the investigations have been completed, the commission can issue a report with recommendations to the parties. But as Dick mentioned, such a fact-finding commission has never actually been implemented for fear of politicizing humanitarian law. So, in conclusion, international human rights law and humanitarian law have succeeded in promulgating and codifying relevant standards, as well as in encouraging broad acceptance of treaties and other instruments. The International Criminal Court and several ad hoc criminal tribunals have been established to prosecute war crimes as defined by humanitarian law, as well as to punish the crime of genocide and crimes against humanity, which include the most serious violations of human rights and humanitarian law. There are many other national, intergovernmental, regional, and non-governmental mechanisms which principally implement human rights law, but also humanitarian law. In addition, the International Committee of the Red Cross plays an important role in encouraging states to comply with humanitarian law and interpreting humanitarian law. I think I did it within the time that I expected, and with plenty of time for Dick to take over. I could take questions, but I think it would be fairest if Dick